Hi, my name is Andrea Reed. I'm of counsel with the Boston-based IP firm Lando Anastasi. This short video segment will cover important intellectual property cases currently pending before the Supreme Court of the United States and trends in IP litigation. First, a look back. For the 2021-22 term, the Supreme Court denied all petitions on patent cases. But interest in patent cases is trending up. For the 2022-23 term, which is what we're in now, the court is showing renewed interest with 4 IP cases already on the docket and, at the time of this video, 4 more with potential to be added to the docket if the court grants certiorari. One case has already been argued this term. It's a copyright fair use case brought by the Andy Warhol Foundation for the Visual Arts against celebrity photographer Goldsmith. The Foundation and Goldsmith are at odds over 2 depictions of the rock star Prince. The issue is whether Andy Warhol's famous silkscreen paintings, based on Goldstein's 1981 photograph, were sufficiently transformative to constitute fair use because they convey a different meaning or message. Fair use refers to a doctrine that promotes freedom of expression by permitting the unlicensed use of copyright-protected works in certain circumstances. Here, the Supreme Court's decision is expected to clarify the doctrine and address whether courts may consider a work's meaning or message relative to its source material. The next 3 cases are not yet set for argument, so watch the calendar. Amgen v. Sanofi is a big one for the life science industry. Interestingly, the Supreme Court took this patent case against the advice of the U.S. government. The technology generally concerns pharmaceutical compositions of monoclonal antibodies that lower cholesterol, marketed as Repatha. The issue concerns enablement of Amgen's broad genus claims, which, if upheld as invalid, Amgen argues would be devastating for biologic drug innovation. The word enablement refers to a requirement under Section 112 of the Patent Act. It simply means that a patent must contain sufficient disclosure to make and use the invention without undue experimentation. Here, the Supreme Court's decision is expected to clarify whether the enablement analysis should include consideration of the quantity of experimentation. The next 2 cases are trademark cases. Petronic v. Petronic is being watched by trademark owners concerned of international infringement. Petronic makes remote controls for construction equipment and is trying to recover damages against its former European distributor for selling unauthorized products almost entirely outside of the U.S. Only 3% of the products were destined for the U.S. Normally, the Lanham Act, which governs trademark infringement, can apply to foreign sales, but the issue here is whether damages are recoverable absent proof that those foreign sales cause consumer confusion in the U.S. The Supreme Court's decision is expected to clarify whether a diversion of sales theory could support a damages award. For example, where lost foreign sales deprive an American company and thus the U.S. economy of revenues. The second trademark case is Jack Daniel's v. VIP Products. Jack Daniel's is a famous whiskey brand. VIP Products is a dog toy maker that made humorous use of Jack Daniel's trademarks. The dog toy maker's defense is that it doesn't sell whiskey or otherwise compete with Jack Daniel's, and its toy is a parody entitled to First Amendment protection. So that's one issue, the balance between free speech and trademark rights. A related issue is whether a parody, despite being a commercial product, nevertheless qualifies as non-commercial under the Lanham Act to bar a claim of dilution by tarnishment. The Supreme Court's decision is expected to clarify whether protections traditionally afforded to artistic works, like movies, art, and books, also apply to ordinary commercial products. So those are the 4 cases that the Supreme Court has taken up this term: 1 copyright, 1 patent, and 2 trademark cases. But that's not all. The Supreme Court has requested the Solicitor General's comments in 4 more closely watched petitions. One is another patent case, and like Amgen v. Sanofi, it's a big one for the life science industry. Teva Pharmaceuticals v. GlaxoSmithKline concerns induced infringement under the Hatch-Waxman Act, which establishes a pathway for FDA approval of generic drug products. Generic drug companies use so-called skinny labels to market patented drugs by carving out their infringing uses. For example, the technology at issue in this case is the beta blocker for treatment of hypertension and congestive heart failure sold under GSK's brand name, Corric. GSK accused Teva of encouraging doctors to prescribe the generic drug for congestive heart failure, even though Teva had carved out that use from its label. If the Supreme Court agrees to hear the case, it could have major implications for skinny labels, which Teva says saves patients and the federal government billions. 2 more closely watched petitions include Interactive Wearables v. Polar Electro and Trope v. Travel Sentry, both of which concern patent eligibility. And another is Apple v. California Institute of Technology, which concerns the interplay between patent office proceedings and parallel district court litigation. The Supreme Court will decide whether to grant certiorari in those cases after it hears from the Solicitor General on the Biden administration's views. There's one last patent case that needs to be mentioned here, which, like Amgen v. Sanofi, concerns Section 112 of the Patent Act. It's Novartis Pharmaceuticals v. HEC. To be clear, Novartis only recently petitioned for certiorari, and the Supreme Court hasn't requested briefing from the Solicitor General yet. But the case has potential for broad impact across all technologies, not just the life science industry. The U.S. Court of Appeals for the Federal Circuit invalidated Novartis's patent on loading dose regimens for its multiple sclerosis drug, Gilenya, because the patent included a negative claim limitation that was not disclosed in the patent specification. A negative claim limitation simply means that the patent claims the absence of something instead of the presence of something. The dissenting opinion, and Novartis's petition to the Supreme Court, argued that the Federal Circuit improperly created a heightened standard for negative claim limitations. Well, there you have it, a busy 2022-23 term with trends showing the Supreme Court's increased interest in patent issues, and in particular, those affecting the life science industry. I'm Andrea Reed, and I hope you found this summary helpful.